May I have your Lordship's permission to commence the proceedings of the ceremonial bench to mark the completion of 75 years of the establishment of the Supreme Court of India.
Please.
May I now request Learned Attorney General for India to address on this occasion.
Honorable the Chief Justice of India, Honorable Judges of the Supreme Court, Mr. Kapil Sibal, President SCBA, President and Office Bearers of the SCORA, Solicitor General, and law officers. Standing in the precincts of a sentinel on the Quivi, the Supreme Court of India, on a solemn occasion like this is a matter of great privilege, and as etching an important milestone in our constitutional history. The inauguration of the Constitution saw inauguration of several facets of rule of law. The grand inaugural speech delivered by Chief Justice Kaniya seems fresh and contemporaneous. The 75th year of constitutional adoption, beyond any question, is a matter of both celebration, buoyancy, and an occasion for planning and laying our roadmaps for the future. 75 years of constitutional rule without serious breakdown is no mean achievement. We must indeed celebrate the resilience of the Constitution and the endurance made so by all participants of a democracy. We must celebrate its endurance by plunging into the history of our constitution making, the sacrifices made by millions of people laying the foundations of freedom and liberty, not less than Magna Carta, and the remarkable contributions made and insights bestowed by the makers of the Constitution. We must celebrate its endurance without mutilations as part of a democratic journey, as special, distinct, and worthy of emulation. We must celebrate its endurance equally as part of the faith and commitment which we, the people of India, have placed in rule of law as informed by the Constitution. We must celebrate its vibrancy, reflected in elections after election, and all the safeguards thoughtfully provided by courts on every needed occasion. We must celebrate the jurisprudential contributions of deep reflections and visions of the Supreme Court and the High Courts in the high promotion of its transformative potential and in conveying to the nation, the Parliament, and the institutions of governance values of inclusiveness, diversity as part of our equality journey. This stately building is home to visionary constitutional doctrines and thoughts which have sustained our democratic fabric. The lawmaking experiments and parliamentary engagements in deftly handling complex questions of social management without rocking the basic structure, though making some scratches, are matters of celebration too. Permanence and endurance are sustained by flexibility, long ago stated by Thomas Jefferson in 1824 when he wrote, I quote, "The real friends of the Constitution in its federal form, if they wish it to be immortal, should be attentive by amendments to make it keep pace with the advance of the age in science and experience," unquote. Dr. Ambedkar had this and other experience from history in his mind when he said in his concluding remarks in the Constituent Assembly in 1949, he said, "The first thing in my judgment we must do is to hold fast to constitutional methods of achieving our social and economic objectives." He also talked about the drift with mastery. We have now by chiseled into a constitutional practice what we can do and what we shall not do. How we are able to do so in the midst of globalization challenges is demonstrated by our recent engagement in striking several balances in the economic domain, policy, and international relationships. All this is because of our unflinching commitment to the Constitution and its demands on our intelligence and the non-negotiable roots of building a fair and just society. Our national fiber, made of thousands of years of incomparable togetherness, born of deep spiritual and cultural values, and our constitutional fabric have now seamlessly merged that no force or attempt can undo. That we are yet to satisfy the needs and concerns of large numbers of our people in want and fulfillment is all the more reasons for continuing on the paths laid. All this celebration we must do as we note how fissures and fractures have perilously exposed several nations to constitutional and democratic breakdowns. We must do so also to set at rest shallow cynicism about Indian state and bring to command all our genius in our march towards a fair social order. An American law academic, writing about the timeless lesson for the issues of our era, though from the US lens, says, quote, constitutional law is a practice like surgery or chess. We can indeed write on how our constitutional journey has been more of a chess than deep surgery. Talking of the engagement of Eastern Europe for the last decade of 20th century, in many different ways, revolutions, armed, economic, cultural, political, and social, it is said that none of these are more dramatic and perhaps none so successful as its constitutional reforms. The voice of our worldly members of the Constituent Assembly seem to resonate today with all these ideas. The legal fraternity of India, being a proud partner in this remarkable journey, will continue to play a role in more and more nobler ways and chronicle our genius to the rest of the world. I thank in gratitude for today's ceremony.
I now request Learned President of the Supreme Court Bar Association to deliver his speech.
My Lord, the Chief Justice of India, Shri Sanjeev Khanna, Honorable Judges of the Supreme Court of India, my friend, the Attorney General, the Solicitor General, law officers, Executive Committee members of SCBA, the President of the SCORA, Executive Committee members of SCORA, my colleagues present here. As we gather here today to reflect on 75 years of this great institution, I want to begin by paying homage to those who brought us freedom. We pay tribute to the sacrifices made by millions who resolved to fight the might of the empire with the weapon of nonviolence. Used for the first time in any freedom struggle, this weapon signified a moral authority more powerful than the threats, violence, the criminal dehumanizing acts our people were subjected to. It is this hard-won free independence and this defiant allegiance to democracy that this court has been tasked with protecting, bringing dignity, autonomy, and mutual respect to the everyday lives of ordinary people. Right since its inception, our court has had no hesitation in deciding cases as per law without undue favor to the all-powerful state and with no regard to the political popularity of the policies in question. It was this independence that had the court questioning by 1964 whether the government had unlimited powers to amend the constitution to take away fundamental rights in Sajjan Singh's case. In 1967, to protect individual liberties, the court held that the government had no power to amend fundamental rights in the landmark judgment in Golaknath, refusing to accept the argument that if the government was stopped from amending fundamental rights, there would be chaos. Finally, the impasse ended with the Supreme Court propounding the famous basic structure theory that disallowed amendments to the basic features of the Constitution in case of Nand Bharti. Faced with blowback in the form of judicial supersession and unprecedented transfers impacting the independence of the judiciary, and in time judicial review, the court in S.P. Gupta and later in Supreme Court Advocates and Record Association evolved the collegiate system to protect the judiciary from the executive. In Bomai, the court came down heavily on the abuse of 356 to dismiss state governments for political reasons. In Vadhva and Krishan Kumar Singh, the court struck down repeated ordinances to bypass lawmaking to be a fraud on the constitution. In essence, the court has been responsive to the needs of the political environment and has sought to best preserve the constitutional vision of our founders despite the continual stresses and strains in our chaotic democracy. An area where the court has left an indelible mark is in the area of fundamental rights and civil liberties. The difference between A.K. Gopalan on the one hand and R.C. Cooper and Maneka Gandhi on the other, or between M.P. Sharma and Puttaswamy, Swamurthy Vishnu Joseph Shine, Suresh Kumar and Kaushal to Navtej Johar, Champaran Dorerajan to Indira Sani, or Anwar Ali Sarkar to E.P. Royappa is one born of a deeper understanding of fundamental rights, what they mean, how they relate to each other, and how they empower citizens. In this journey, the court has relaxed the requirements for legal standing to enable public interest litigation by public-spirited persons to bring to light injustices suffered by the powerless or deal with large-scale problems like bonded labor or the environment. The Supreme Court has developed an enviable jurisdiction on fairness in administrative action using doctrines such as promissory estoppel, Motilal Padampat, proportionality, modern dental, manifest arbitrariness, Shaira Bano, and the principles of natural justice, Indo-Afghan agencies, etc. Its curative positions have opened a jurisdiction to correct errors quite unknown to the rest of the world. In 75 years, we have seen many great judges and chief justices, Justice Mukherjee, Justice Bose, Justice Subbarao, Justice Hidayatullah, Justice Krishna Iyer, Justice Venkachalaya, and many others. There can be no better example of judicial independence and courage than H.R. Khanna. They have been trailblazers and a model to follow. This is not to say that the court has not on occasion erred. The infamous Jabalpur, ADM Jabalpur judgment where this court did not heed the wisdom of the high courts and ended all constitutional means to combat the emergency is an indelible stain. There are cases where the court should have intervened and did not, or where it has intervened in matters where it lacks both institutional competence and legitimacy. The question remains and to be asked, does the court retain the elements of what has made it so great in the past? Will the court continue to be an indispensable institution in our democracy? I am confident that it will, if it avoids certain pitfalls. First, the court must find a way to solve the enormous backlog. Second, the court's strength lies in the principles of open justice, where the most persuasive argument ought to prevail, and the power of argument must prevail over the argument of power. This means that the judiciary must eschew excessive secrecy and embrace a more open way of being. Third, the court must find a way to ensure that polyvocality, 15 different courtrooms, do not become 15 independent courts. Stare decisis and judicial consistency are the embodiment of the rule of law. Fourth, the court must not forget that the primary quality of predecessor judges who are remembered in their courage to defy conventional wisdom, to follow the untrodden path, to do the right thing. Courage is contagious, but so is cowardice. Our Constitution and its own proud history both demand that the court always stand up for our values, our freedoms, and our hallowed democracy. Our Constitution is at once accessible and sublime. Its message is loud and clear in the heart of all patriots. When we look at the history of independent India as outsiders or historians, we note that when faced with difficult odds, the Constitution has found its unassuming champions, not in the least among the bar and on the bench of this august court. This Bible of ours instills in us the values that we need to cherish, the values of sovereignty, of protecting the security of the state, of ensuring that our freedoms are not trampled upon, as this republic, through its democratic processes, seeks to realize the aspirations of ordinary folk at the bottom of the ladder. While the Republic has done human service to us in the past, we need to remain vigilant. This court must be the champion of our Constitution and bring to life the values of constitutional morality hidden within the cold print of the articles of the Constitution. These are interpreted by our great judges who truly understood, when confronted with challenges, the meaning of the constitutional values that permeate each article of the Constitution. These values need to be preserved. And we, the members of the bar and the judges, owe our allegiance to the rule of law, the upholding of which is our solemn responsibility.
My esteemed brother and sister judges, Sri R. Venkataramani, Learned Attorney General of India, Sri Tushar Mehta, Learned Solicitor General of India, Sri Kapil Sibal, President Supreme Court Bar Association, Sri Vipin Nair, President Supreme Court Advocates and Record Association, members of the bar, and the registry officials. As we gather today to commemorate the 75th anniversary of first sitting of the Supreme Court of India, we stand on each historic occasion at an intersection that connects the history, the present, and the future. What began in 1950 as a successor to the Federal Court has evolved into perhaps the world's most vibrant and dynamic apex court that truly embodies the aspirations and diversity of 1.4 billion people. What sets the Supreme Court apart from the global stage is its unique character as a true people's court. The court remains accessible to common public, and in its diversity, the judges in the courtroom, the multitude of voices finds representation at the highest level of our judiciary. Each decade of our court's jurisprudence serves as a mirror of the nation's challenges. The rings of a mature tree that reflects its journey through different seasons, these judgments reflect not just the legal evolution, but our country's very pulse. What emerges is an unmoving structure carved in a sandstone, but rather a living and breathing institution. It has been responsive to the conscience of a democracy, adapting and evolving to embrace the complexities of each era while remaining rooted in the bedrock of constitutional values. The first decade, 1950, the sunrise years. In 1950, when we adopted the Constitution, the three wings of the government were assigned distinctive responsibilities. The monumental task was to transform a newly independent nation into embodying the values, the ethos, and morality of our Constitution. In Dr. B.R. Ambedkar's words, constitutional morality has to be embodied in nation building. It has to be cultured in a nation like India, where everything is newborn. To achieve this ideal, the Constitution bequeathed to the Supreme Court of India a wide and expensive jurisdiction. In its inaugural sitting, the first Chief Justice of India, Justice Kania, had said, Supreme Court will decide and interpret the laws of the land, but not in the spirit of formal and barren legalism. One of the court's earliest decisions, and Ramesh Thapar, pronounced on 26th May 1950, set the trend. The freedom of speech and expression guaranteed by Article 19 of the Constitution, it elucidates, is a right that could be restricted only under 19(2), which provides for certain reasonable restrictions. In another case, it was held, liberty of an individual and the protection of fundamental rights are the very essence of the democratic way of life adopted by the Constitution. And it is the privilege and duty of this court to uphold these rights. This court would naturally refuse to subscribe them or curtail them except as provided by the Constitution itself. The second decade of 1960s, the years of anchorage as well as discovery. In 1960, the sanction strength of this court was expanded to 14. The most significant judicial event of 1960s turned on the interpretation of a single word, law, in Article 13 of the Constitution of India. Article 13 provides a law inconsistent with or in derogation of fundamental rights are, to the extent of inconsistency, void. The courts were tasked to interpret whether the expression law used in Article 13 included constitutional amendment. If it did, then whether the chapter on fundamental rights could be rendered immune from amendment. The discussion continued till the 70s until settled in Keshwananda Bharati's case, where majority of the 13 judges bench held that the Parliament can amend any provision of the Constitution. However, such amended powers cannot be exercised to abrogate or destroy the basic or fundamental features of the Constitution. 17 and 80s were years of turbulence, leading the way to social justice and equality jurisprudence. Acceptance of public interest litigation diluted the principle of locus standi to actualize the right to access to justice to all citizens, importantly to the marginalized. Justice Krishna had reason that legal technicalities should not become an added terror for the underprivileged. Acknowledging this unique socio-economic constraints, this court in S.P. Gupta emphasized that it was necessary to democratize judicial remedies. In Hossain Khatun, this court dealt with the rights of under-trial prisoners, highlighting the right to speedy trial and resulted in release of more than 40,000 under-trial prisoners. Critical issues of juveniles and other prisoners were dealt with by this court in Kardia Pandian's case. In Insulit Batra, the court highlighted the prisoner's right and systematic issues in administration of justice. In D.K. Basu, this court observed that custodial violence strikes at the blow of the rule of law it issued several directions to be followed in all cases of arrest or detention till suitable provisions were incorporated in the Code of Criminal Procedure. In Joginder Kumar, this court emphasized that a police officer may have the power to arrest, but an arrest should be only made after reasonable satisfaction was reached as to the genuineness of the complaint, to the person's involvement and need to arrest. In Mukherjee versus State of Punjab, the mandatory death sentence under Section 303 of the IPC was struck down as unconstitutional. In Indira Gandhi versus Rajnaran, this court emphasized that judicial review and fair elections were a fundamental part of the Constitution beyond the reach of the amending powers of the legislation. In Bandhua Mukti Morcha, bonded labor was categorized as incompatible with Article 21, which includes protection of health of workers, women and men against abuse. In the initial years, this court had interpreted all fundamental rights as rights working in exclusive silos. The judicial attitude, however, underwent a significant change after the emergency was imposed in 1975. In Maneka Gandhi, this court ruled, attempt of the court should be to expand the reach and ambit of the fundamental rights. Articles 14, 19, and 21 were not mutually exclusive and had to be read together so that the procedure affecting any of the rights had to be just, fair, and right, and not arbitrary, fanciful, or oppressive. 1990s was the era of consolidation and expansion of fundamental rights. 1990 ushered in an era where the Supreme Court not only remained vigilant to protecting human rights, but also stepped in to address legislative and executive gaps. The court adopted an expansive interpretation of fundamental rights, reading them harmoniously with the directive principles of state policy. In Uniconnect Christian, this court held that the right to an education naturally flowed from the right to life recognized under Article 21 of the Constitution. This led to insertion of Article 21A in the Indian Constitution and enactment of the Right to Education Act in 2009. This court has also been at the vanguard for protection and preservation of environments. In its judgment, the court has articulated the concept of sustainable development, the polluter pays principle. It has also applied the public trust doctrine in several cases, highlighting that public has the right to enjoy common resources, with the state being entrusted to guard and maintain these resources. In Vishaka, this court laid down a set of comprehensive guidelines to prevent sexual harassment at work. The guidelines laid down in Vishaka were eventually led to enactment of the legislation after considerable time in 2013. In Indira Sani, a 9-judges bench of this court held that affirmative action is not an exception, but a tool for guaranteeing equality of opportunity. While the Constitution creates a sound center, it also educates a balanced federal structure. It is one of the basic features of a Constitution, and that cannot be abrogated by constitutional amendment. This was the crux what 9 judges of this court had held in S.R. Bommai. S.R. Bommai also has implication for the secular fabric of India. The court inter alia held that secularism is a basic feature of the Constitution. 2000 till today. The 2 decades after the 21st century stand as a testament to the Supreme Court's evolving role in a constitutional framework. No other epic course worldwide navigates such an expansive domain, from personal liberty to environmental issues, from intellectual property rights to privacy to right to information. The evolution began with strengthening of electoral democracy by establishing voters' right for information about candidates as to extension of freedom of expression, which includes the right to impart and receive information. The court dismantled gender stereotypes in employment, rejecting outdated restrictions on women's workplace participation. Digital rights emerged as a new frontier for the constitutional protection. The court struck down vague restrictions on online speech, extending constitutional safeguards to judicial spaces. In socio-economic justice, it broadened affirmative action to include economic criteria, recognizing diverse forms of disadvantage in the modern society. Apart from public law, these court decisions have strengthened India's economic landscape by injecting clarity, efficiency, and fairness, be it in Solvency and Bankruptcy Court or Arbitration and Conciliation Act. This court has also strived to strengthen alternate dispute resolution mechanism. Public understanding of justice has evolved from pure legal construct into a living force that touches across the lives in the nation. While the court's journey reflects remarkable evolution of right and reach, three challenges demand our attention. The first is the weight of areas which continues to delay justice. The second, mounting cost of litigation, which threatens true accessibility. Third, and perhaps most fundamental, justice cannot thrive where and when falsehood is practiced. These challenges mark the next frontier in our pursuit for justice. 75 years after our constitutional journey began, the Supreme Court stands transformed, yet anchored in its foundational mission. This transformation reflects a deeper recognition that justice must be principled and practical. In doing so, it makes the constitutional promise of justice, social, economic, political, a reality for millions of Indians. Over the 7.5 decades, this course has transformed constitutional promise into reality through its judgments. Jai Hind.
May I have your Lordship's permission to conclude the proceedings of the ceremonial bench?